right. What is happening with this case?
Judge, we've reached an agreement with the police office to have an extension of her probation and amend the conditions.
All right, we'll see if I go along with that.
Yes, Judge.
All right, court is calling 2021 CR 1907, State of Texas versus Vanessa Rosado. Could I have parties announced for the record for the state?
Jason Marahan, Your Honor.
For the defense?
Monica Corolla?
Are you Miss Rosado?
Yes, ma'am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review this document
Yes, ma'am.
with your attorney? Did you understand it?
Yes, ma'am.
All right. Are you the same Vanessa Rosano who was placed on deferred adjudication in 2021 CR 1907 for the offense of theft of aluminum, bronze, copper, brass on March 1st, 2022 for a period of 2 years? Is that you?
I'm sorry, Judge.
Oh, no problem. State?
I'm sorry, Judge. Can you
That's
just have
okay,
me over?
sure.
Which one is she going? This one. Violated condition number 2 on or about the 31st day of October 2022 in Bear County, Texas. The defendant Vanessa Rosano did then and there legally use a controlled substance, namely methamphetamine, in violation condition number 2.
How do you plead to that? True or not true?
And Your Honor, we'll waive the remaining violated conditions.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That is to deny the motion to adjudicate guilt, continue on her deferred, extend for 18 months, refer to felony drug court, also have GPS for 3 months, also weekly UAs, also parenting classes, also report 2 times a month, or in person or in Zoom, Your Honor, and that would be the agreement.
All right. Are you asking the court to follow that agreement?
I am, Your Honor.
Are you asking the court to follow that agreement? The fact that the state is asking so much of you and probation is asking so much of you tells me you've done nothing. So I'm going to give you a choice because I don't know if you're going to be successful or not, but it appears that you have done nothing. And I'm looking at the docket sheet, and at the docket sheet.
At this critical moment, the court reviews Vanessa Rosano's probation violations. After admitting to methamphetamine use, she faces a life-altering decision: accept an 18-month state jail sentence or extend probation under strict conditions. The judge makes it clear this is not just punishment, it's a final opportunity to choose accountability over incarceration.
At first, this was supposed to be a pretrial diversion, and all you had to do was pay $547 for that to be done. And then we've had a motion that has been filed before, and that has been withdrawn. And now we're back here. So here's your choice. I can extend you for 2 years. I'm not going to extend you for 18 months. I'll extend you for 2 years. Or either I'll sentence you to the state jail facility for 18 months. You'll complete it. You'll be done. You can do what you want to do with your life. Otherwise, I'm going to continue you, and I'm going to follow these recommendations.
And my choices, what was the previous?
18 months in the state jail facility, or either you're going to be extended for 2 years. There'll be a referral to felony drug court. You're going to remain in custody till felony drug court accepts you. If felony drug court does not accept you, you're going to safety. So which would you prefer?
The second, the 2 years instead of the 18 months.
Okay. All right, the court will deny the motion, alternate amend conditions to include a 2-year extension a referral to felony drug court. If not accepted, then safety. And this is all to be done in custody. Parenting classes. There's to be no unsupervised contact with minors. There is to be partial GPS for employment only. No employment as a home health care provider or with minors. The UA hotline until further notice. And field visits 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
Your Honor, if I could just provide the court with a little bit of information with regard to the parenting class
Yes.
that's been added as a condition. Ms. Rosano has a 2-year-old grandchild in the house where she lives. She has a 24-year-old son who suffered from significant mental health issues last year, which is how Ms. Rosano ended up caring for his child. He has gotten the mental health assistance that he needs. He's on medications and he's actually gainfully employed and living outside of Ms. Rosano's home. However, the grandchild still does reside with her and she is charged with taking care of him. This is something that she volunteered to do as a grandparent. It was her responsibility and her heart to do that. The unsupervised visitation that the court just imposed as a condition of that probation. In light of those circumstances, I was wondering if you'd reconsider the unsupervised visits that you impose. It has nothing to do with any dangerous conditions in her home that she has created. I do understand she has a positive or an admission to using methamphetamine in 2022. However, that was prior to her having a grandchild. So I don't know if the court would reconsider unsupervised
Well, let me
visitation.
ask this. Has she been reporting? I know that's an allegation.
As the hearing continues, deeper concerns emerge about child safety and responsibility. The court questions whether someone struggling with substance use can safely care for a young grandchild. With reporting failures and unanswered drug testing concerns, the judge prioritizes protection and structure over leniency, imposing firm conditions to safeguard the child's well-being.
In the motion, but there was no plea of that. So has she been reporting?
Correct. That was, she has not been reporting, which is why we suggested a GPS for 90 days to get her back on.
Has she
track.
done any, since she hasn't been reporting, that means that she hasn't done any UAs. Am I right in assuming that?
I believe that would be a safe assumption.
All right. So I don't know if she's using meth or not, but I do know if you're using meth, you shouldn't be babysitting anybody's grandchild,
True, I agree.
right?
And-
All right. So that's where we are. There's to be no unsupervised contact. And I don't know if Child Protective Services are involved or not. They probably should be. If the option is your son has mental health issues, so he should not be alone with the 2-year-old, and then you're using meth. That's not a good combination for either parent for a child if your son is not on his medications.
My son, he's taking Zoloft, he's been taking Zoloft for almost half a year now.
All right. So then that's where we are.
Yes, Judge.
All right. Thank you.
Thank you.
Thank you, Your Honor.
All right, if you need anything, you feel as though probation is not addressing the issue, you can always come back to the court. Do you understand? All right, thank you. Ray Espinoza.
Robert, great.
Case.
Yes.
Good morning.
Good morning.
So Hank and I have been conferring. We, at our last setting, because of the nature of this case, we had dropped off a thumb drive for the state to do all of the discovery.
Mhm.
I think that got caught up in the DA's office through some hands, and we are still waiting for that to be returned.
Just to make the court and defense counsel aware, so on December 19th, I gave this to the paralegal, and asked her to put all the discovery from this JN number onto the flash drive, and I haven't gotten that back yet, so I did email this morning, hey, have you had a chance to do that yet? So that's kind of where we are, Judge. So I'll follow up with the paralegal assigned to our court if I don't get a response.
All right, so do we know, has everything been placed on the flash drive or the hard drive, but it's just missing?
I am not sure, Judge. I've given her the flash drive and I asked her to put the discovery on it, but I haven't spoken to her about this particular flash drive yet.
I will tell the court, I print out labels, so it's heavily marked with Mr. Espinosa's name and our contact numbers.
All right, so we're going to come back on March 29th.
March 29th.
I'm sorry, not March 29th. This calendar that's on my computer is all over the place. We're going to come back on February 29th.
Okay, is there a 29th this year in February?
Yes, there is. According to this calendar, there is.
Okay.
Yes.
Double checking.
Double
Okay.
checking, yeah.
Election.
And he's telling me no. He didn't even check. He's just like, and he said it with such conviction.
He did say it
No,
with conviction. He
Yeah,
did.
but I was like, this is a leap year?
no, we're good.
Okay, February 29th, Judge.
Yes.
Thank you so much.
All right, thank you.
Do you need to talk to us?
All right, after this next case, then I'll take up the warrants that have been sent to me. Robert Grant,
Thank you.
yes.
Mr. Grant.
Hello.
The courtroom shifts to procedural matters as attorneys discuss missing discovery evidence and scheduling delays. A simple flash drive becomes central to ensuring due process. With deadlines clarified and a new court date set, the judge reinforces the importance of preparation, transparency, and accountability in every stage of the justice process.
All right, what is happening with this case?
I've conferred with Daniel and given him some evidence that he wants to follow up on. And can we get a 1-week reset? It's for possible dismissal.
All right, so we're going to come back then on February 8th.
Yes, Judge.
All right, I'll give you a reset form and then you are excused, and of course defense, if the state decides to dismiss this case before that time, then your client may not need to show. But for now, you're going to be back in court on February 8th. Do you understand?
Yes, ma'am.
And can I check my calendar just to be sure?
Okay.
Can it be the 6th or the 9th, Your Honor?
All right,
6th, preferably the 6th.
all right, I'll put you down for February 6th.
Thank you.
You're welcome. All right, once you sign the reset form, you are excused.
Thank you.
You're welcome.
But you keep looking.
Yes.
It's a motion to substitute.
Ah, so here's the question. So in this case, I gave this to you yesterday.
It just got a